लद्दाख के लिए और व्यक्तिगत मेरे लिए सबसे बड़े दुख का दिन है, क्योंकि जिस रास्ते पे हम 5 साल से चलते आए, शांति का रास्ता था, जिसमें हम खुद पे दर्द और दुख लेते थे.
They had this video, but they did not rely upon it. You will see, Malad, that we are on the dais where the violence is taking place, and I'm saying, stop it. Before we go into the nitty-gritty of it, let me first indicate to your lordships my first and the foremost point, Malad, which is, Malad, that the proximate causes that ultimately led to the detention order.
Ask her to sit. Here is standing man,
The proximate causes that led to the detention order, which is on 26th of September 2025, were 4 videos, which are relied upon by the detaining authority. These videos are dated 10th of September, 11th of September, 24th of September, and another one on 24th of September.
Yes.
The grounds of detention refer to these videos, and the grounds of detention were supplied to me on the 26th.
To the detainee or to the petitioner?
To the detainee. So there's no grievance there. The grievance is that the 4 videos were not supplied.
Which was relied upon.
Relied upon. Your lordship knows, Mullah, the law is well settled.
Thank you.
The law is well settled that if the grounds of detention are supplied and all documents relied upon on the grounds of detention are not supplied, it will vitiate the order. That is settled law in the context of Article 22, Sub-Article 5.
Yes.
Along with Section 8 of the National Security Act 1980. It is our case that they were not supplied. It is their case they were supplied. That's what they say. They don't demonstrate it.
Okay.
But they say they were supplied. So I'll show to your lordships, Mullah, the paintings on this. And if your lordships are with me on this, there are other issues I need not go into. This is my Article 22(5) of the Constitution mandates that the authority making the order shall, as soon as may be, communicate the grounds on which the order has been made to the person detained. And 2, the detaining authority shall afford to the person detained the earliest opportunity of making a representation against the order. Clause 5 of 22 incorporates a dual requirement. First, of requiring the detaining authority to communicate the grounds of detention as soon as may be. And second, of affording to the detainee an earliest opportunity of making a representation. Both these procedures are mutually reinforcing. The communication as soon as may be of the grounds of detention is intended to inform the detainee on the basis of which the order of detention has been made. The expression as soon as may be imports a requirement of immediacy. But the point that really the underlying constitutional issue is the following. Why is the 5 and 10 day limit given? It's given because at the earliest possible time, you should get all the documents. Why? Because the advisory board is to meet much later. So, well, that's really the law on the subject. So the facts are established. The law is clear. And my request to your lordships is, if your lordships are inclined to look into this and decide the matter, then I need not go into the other facts. Let's
cover everything so that suppose we accept it, we may not go into other aspects.
But if the facts in this are clear to us, then
let it not be in piecemeal, Mr.
All right.
So that we can once and for all, so that you close it.
All right.
Suppose we accept the first point, we will not go into other points at all.
Okay. Well, the thing is that will take a lot of time.
No. Take your time.
I have studied, this is the detention order. I have received a recommendation from SSP Lay for detention of so-and-so. I have studied the details given in the recommendation and perused the enclosed documents and materials in this regard. And after a thorough consideration, I, Romil so-and-so, district magistrate, am fully satisfied that Sonam Wangchuk have been indulging in activities prejudicial to the security of the state, maintenance of public order, and services essential to the community. And circumstances prevail within the local limits of the undersigned jurisdiction, which indicate that your conduct and action are prejudicial to the maintenance of public order, and therefore it is necessary to make an order directing that you be detained with a view of preventing you from indulging in the above mentioned prejudicial activities in future.
For what proposition?
What is your proposition?
of
Let's hear
second-
the recommendation that is made is also not given to us. Kindly see, I have studied the details given in the recommendation were used in the enclosed documents. Not given. With that, we do when the grounds, we leave the grounds. No? That my conduct and action, that means essential maintenance of public order and services essential to the community and circumstances prevailing within the local limits. So, Malats, my detention is necessary because it may affect public order, maintenance of public order if I am not detained, and may affect the services essential to the community, which indicate and circumstances prevailing within the local limits. So they are considering three elements. What are the circumstances within the local limits? If I am not detained, it may lead to activities prejudicial to the security of the state, maintenance of public order, and services essential to the community. That's why it's necessary to detain. With the idea that we need to detain you because otherwise you will continue with your activities. It's very important. With a view to preventing you from indulging in the above-mentioned prejudicial activities. I made a speech breaking my hunger strike. I broke the hunger strike after the 15th day. And what I said was that I cannot accept this violence. And I said, you should stop this violence. I don't want to be part of it. I appeal to you to stop it. That's the video I wanted to play to your Lordship. And I am therefore, because of this violence, giving up my hunger. Understand? Your Lordship should remember, mothers, Gandhiji did the same. The moment there was violence with his Chauri Chara or anybody else, he did exactly the same. Now, the idea was that I did not want to continue to be in hunger strike because of violence. But that speech of mine is taken to be interpreted in a manner that if I am not detained, violence would continue. That's the point I'm trying to make. Means my speech, which in fact says that I am against violence, is taken to be such that if I were not continued in detention, if I were not detained, violence would continue, while the intent was exactly the opposite. Now, they had this video, but they did not rely upon it. We have included it in our petition. And if your Lordship's permission, Malad, I'd like to play that. You will see, Malad, that we are on the dais where the violence is taking place. And I'm saying, stop it.
लद्दाख के लिए और व्यक्तिगत मेरे लिए सबसे बड़े दुख का दिन है, क्योंकि जिस रास्ते पे हम 5 साल से चलते आए, शांति का रास्ता था, जिसमें हम खुद पे दर्द और दुख लेते थे.
The tenor of this speech is, Malad, not in any sense threatening the security of the state.
Yesterday in the Supreme Court of India, a critical hearing unfolded in the detention case of climate activist Sonam Wangchuk, who has been held under the Stringent National Security Act (NSA) since September 26, 2025. Appearing for Wangchuk's wife, Dr. Gitanjali Angmo, senior counsel, Kapil Sibal argued before a bench led by Justice Aravind Kumar and Prasanna B. Varale that the NSA detention order is fundamentally flawed. At the heart of the challenge is the non-supply of key evidence, specifically 4 videos that the retaining authority relied on when issuing the order. Sibal told the court that these videos were never furnished to Wangchuk, depriving him of the basic right to make a meaningful representation and undermining constitutional safeguards. In a dramatic moment, clips were played in court showing Wangchuk's speeches, which his lawyers say a plea for peace and restraint, not violence. They argue that this contradicts the government's claim that his actions were prejudicial to public order. The bench indicated that if finds evidence was intentionally withheld, it may not need to examine other arguments, hinting at possible relief. However, the court reserved further consideration and has posted the matter for continued hearing on January 12, leaving the fate of Wangchuk's detention unresolved for now.